My ex has never been there for the kids, but all of a sudden wants 50-50 custody in divorce. What can I do? Hi, I'm Bill Farias, founder of Farias Family Law. This is a very common question that we get where you have a parent who hasn't been very involved, but divorce is on the horizon, and for a number of reasons, people want to be more involved with the children. Some of them are good and genuine reasons, some are not. So the best way to approach this is to, first of all, gauge the level of interest and assess how genuine it is. And what I mean by that is you have some people who take this position of all of a sudden wanting more time with the children because they believe it's going to minimize their financial obligation. And when that's the case, that's a red flag, right? Because that means they're not really interested in more time with the children. They're interested in decreasing their support payment. And that has the potential to be a real problem. And so rather than outright dismissing it from the outset, just ask some questions. Dig into it. Try to get a feel for what's going on. Is this a financial play? Is it they have a new person in their life? Like, for example, you'll have a parent who all of a sudden has a new significant other who starts to push them to get more time with the kids for whatever reason. That's another red flag, right? But on the other hand, if you have a parent who is genuinely interested in spending more time with the children, who wants to play a bigger role in the child's life, then that's something that you should consider, right? Because it's in the children's best interest to have two involved parents. And whenever it's possible, and whenever both parents are involved and invested and the communication is good, then having both parents spending significant amounts of time with the children and playing significant roles in the children's lives is actually best for the children. So that's why step one is so important, because you need to figure out where this is coming from. If it's real, if it's genuine, it might be something that you want to nurture. If they're doing it for other reasons, for selfish reasons, that's something you need to figure out. So that's number one, assess where it's coming from. Number two, keep a log of the parenting time. So what you want to do is, first of all, you want to go back historically and you want to document or recount what the breakdown in the parenting responsibility has been. This is something that judges pay a lot of attention to. They're going to look at when the children were babies, when the children were growing up. Right now, which parent is doing what? Who is responsible for dentist appointments, doctor's appointments, activities? Who's getting the kids up in the morning? Who's putting them to bed at night? Bathing, you name it. So you want to break down and you want to document to the extent possible what the history has been, okay? You also want to document what is happening right now. Most importantly, what's happened since the split. So since you have been split up, what has the breakdown in parenting responsibility been? If you have split up. If not, and you're still living together, then you're still documenting who is doing what, who's spending how much time with the children. And you're going to need this because you really need accurate and reliable information about this breakdown. Because if it's a contested issue, this is something that should be presented to the judge, and you want to do it as accurately and reliably as possible, right? If you're going to be caught providing misinformation, misleading the court, that's going to be a real problem. So make sure you're logging and documenting. First of all, go back and do the history and what is happening right now. If you've split up, what has happened since the split? What has the breakdown in responsibility been, and what is the breakdown in parenting time? Finally, you need to assess whether you need to take action in court. And this usually takes the form of what we call a motion, filing a motion to get in front of the judge to ask for a certain parenting time arrangement. And this is necessary when there is a lack of agreement between the parties on what the parenting time should be, right? You don't want to put the children in the middle. You don't want it escalating to a point where there is strain, tension, friction, and certainly not concerning events, certainly not conflict, right? You don't want to let it get to that point. So if you firmly believe that the other party spending more time with the children is not in the children's best interest, then you need to be careful how you handle this. If you are going to allow this parenting time for a significant stretch of time, then if you get in front of the judge after the other parent's already spent all his time with the child, then it's something that the judge is likely to consider. So once you figure out what you think is in the best interest of the child, if you think that there is a possibility that this is going to be a contested issue, you want to talk to an attorney as soon as possible so the attorney can advise you on whether filing and getting into court and having this issue heard is in your best interest. If you have any other questions, you can call us 508-675-0464. You can email us at info@farriersfamilylaw.com. If you found this video helpful, you can subscribe to our channel, share it with anyone you think might benefit from it, and you can find us on social at Farriers Family Law. Thank you. Have a good day.